Welcome to this ICON SGBIE webinar. For those of you who don't know me, I'm Aileen McHarg, and I'm one of the co-chairs of the British-Irish chapter of the International Society of Public Law. I'm delighted to chair this panel discussion of diverse voices in public law, edited by Se-Shauna Wheatle and Elizabeth O'Loughlin, which was published by Bristol University Press in June. Now, this book is a really important and exciting initiative in a field which, to me at least, can often feel rather lacking in diversity, and in which it can be somewhat challenging, I think, to diverge from the standard teaching topics and standard approaches to them. This morning, we're going to hear, first of all, from the book's editors, Se-Shauna Wheatle and Lizzie O'Loughlin. Se-Shauna and Lizzie are both associate professors and colleagues of mine at Durham University. Se-Shauna is a specialist in comparative constitutional law and human rights. Lizzie also specialises in comparative constitutional law, but also English administrative law. We're then going to hear from two of the chapter authors. First of all, Dr. Kanika Sharma, who's a senior lecturer at SOAS. Her work focuses, amongst other things, on South Asian colonial legal history, and her chapter in the book is entitled The Rule of Law and Racial Difference in the British Empire. Then Dr. Ciara Fitzpatrick is a lecturer in law at Ulster University, specialising in social security law and social justice, and her chapter is called The Administration of Social Security Benefits, Gendered Implications. And then finally, we have two respondents. Dr. Vidya Kumar is also a senior lecturer at SOAS. Her research traverses international law, constitutional law, legal philosophy, labour law, and labour and human rights, and legal history. And then bringing some gender balance to what otherwise tends to be a waddle, we have Dr. Suryapratim Roy, who is an assistant professor at Trinity College Dublin, and he currently writes on climate law, citizenship, and Indian constitutionalism. Our speakers will each speak for about 10 minutes, and then we should have about 20 minutes for questions. If you want to ask a question, please post it in the Q&A box at any point, and I will put it to the panel for you. So, with introductions out of the way, I'm going to hand over to Se-Shauna and Lizzie.
Good morning, everyone, and thanks so much, Aileen, for organizing this webinar. What I will try to do is I'll try to share my screen, because we have a few slides that just explain the chapters in the book. So I'll try to do that. There we go. So the book then comes at a time where there's increasing awareness of the inequality that kind of underlies the law that we teach, the sources that we use in teaching that law, and the voices and perspectives that tend to be represented in course content. And it's this awareness that prompted the Diverse Voices in Law series. And this book, the Diverse Voices in Public Law book, is the first publication in the series. And so part of the objective of the book is to amplify the voices of scholars who tend to be underrepresented in the field, and to try to acquaint students with a range of underexplored perspectives on the main topics of public law. And so the majority of chapters in the book are quite decidedly written by women, by minoritized or racialized persons, and by LGBTQI persons. And we've also ensured that a significant number of the contributors are early career researchers. And so the book quite explicitly tries to offer a diversity of voices as well as a diversity of topical perspectives. Now, we do acknowledge that this is just a step, so we're not claiming to give a voice to all voices that need to be heard within the field or to all marginalized groups. But we're hoping that nonetheless that the book will still enrich students' understandings of some of the historical and societal inequities that influence public law norms, and of some of the ways in which current norms and institutions can perpetuate inequalities within our constitutional system. And with that said, then we hope that the book will be a useful resource for students and academics who are seeking to offer more critical and diverse perspectives on their reading lists. So the book consists of two parts. Part one focuses on constitutional structures and concepts, and then part two addresses the individual and the state. So to some extent, it does mirror the typical framing of core texts in the area. However, we try to focus on developing ideas or critically analyzing the complex shaping of contemporary power relations in the UK, challenging some assumptions rather around core principles and institutions of the Constitution. And in part two, especially, we try to look at the impact of contemporary power relations and their impact on the Constitution on disempowered groups within the state. So focusing on the way in which disempowered peoples within the UK interact with the everyday machinery of the state. So quite quickly, I'll just mention what each of the chapters in part one does, and then I'll hand over to Lizzie to discuss part two of the book quite briefly. So part one starts with Kanika Sharma's chapter on the rule of law and racial difference in the British Empire, and Kanika will be speaking about her chapter in a few minutes. And then chapter two also engages with principles that tend to be tied to Dacian legacy. And in that chapter on parliamentary supremacy and the people, Donald Coffey argues in favor of a convention that if parliamentary supremacy is to be altered, then the wishes of the people must be ascertained. And Coffey's insights seek to challenge the Dacian construction of parliamentary supremacy. And we're hoping that his arguments will remain useful in the continued use of referendums in the UK, if we decide to have another one, given how well the last one turned out. The book then moves to looking at executive power, which is the focus of Paul Scott's chapter and Alexandra Sinclair's chapter. Now, Paul Scott, in Strong Executive and Weak Parliament, he engages with increasing arguments that seek to suggest that executive power is derived directly from the electorate. And so he makes the argument that the executive derives its legitimacy from Parliament, and he cautions against the use of powers of the Crown to evade parliamentary will. So again, tapping into or trying to engage with the seeming rise of populism and populist arguments in the UK. Alexandra Sinclair's chapter deals with the role of delegated legislation in the UK and also charts the kind of worrying growth of executive power. And she quite starkly explains that delegated legislation has become the main method of lawmaking in the UK. And she draws extensively on the government's response to Brexit and COVID-19 in making this argument. And in her chapter, she considers some of the constitutional implications of this development. Carrie Brown-Swan's chapter on Scotland's devolution and independence also tackles the issue of power distribution. And so in this chapter, Brown-Swan demonstrates that while the devolution settlement has enabled a dispersal of power away from the center, that mechanisms for governmental cooperation still remain unsettled. And ultimately, she questions whether debates that have arisen from Brexit and COVID-19 and devolution rather mean that the famous flexibility of the Constitution has really ultimately been exhausted. And part one of the book then ends with an exploration of the meaning and importance of diverse voices in the judiciary. And in her chapter, Alicia Blackham conceives of diversity as a broader concept than is traditionally conceived of. She argues that it should really encompass a wide range of personal characteristics and professional pathways. And she argues for a fundamental reconceptualization of the very idea of merit and for a fundamental rethink of judicial careers in order to enhance diversity in the judiciary. Now, part two of the book explores the parameters of the relationship between the individual and the state, and I'll hand over to Lizzie to discuss the chapters in part two.
Thank you very much for that, Se-Shauna. So just picking up from you there, as Se-Shauna said, part 2 pivots to look at, I suppose, the everyday machinery of the state and how it interacts with individuals. It begins with Devyani Prabat's chapter entitled The Begum Case, Discretion and Parliamentary Sovereignty, Unmaking the Constitutional Subject. And in this chapter, she examines the powers of the British state to cancel citizenship as a counter-terrorism measure. She argues that the Begum case demonstrates that any British citizen with other national connections is at a greater risk of being stripped of their citizenship and being rendered stateless. The chapter argues that racialized hierarchies of citizenship status exist and are embedded in British nationality law. Chapter 8 of this part continues with the theme of counter-terrorism measures through the topic of Tufil Chowdhury's chapter, which is entitled Racialization in UK Counter-Terrorism Law and Policy. Chowdhury examines the embeddedness of processes of racialization in the development and implementation of counter-terrorism laws and policy. In doing so, he shows how the development of such policies, including, for example, the PREVENT strategy, which now involves frontline public sector workers identifying individuals who may be vulnerable to radicalization, he demonstrates how such policies encourage processes of racialization. Then Bowling and Shruti Iyer's chapter on racism, law and the police, over 50 years of anti-discrimination law and policing, also highlights the limits of public law protections for racialized minorities. The chapter lays bare the failures of anti-discrimination law in this country, the framing of anti-discrimination laws in this country to reduce racism in policing. And this is a failure that speaks to a violation of the stated shared commitments that we should have to values of equality, fairness, and liberty. Moving to chapter 10, we'll be hearing today from Ciara Fitzpatrick on her chapter entitled The Administration of Social Security Benefits, Gendered Implications. I won't say too much more on that because we'll be hearing from the expert herself on a chapter in which she looks at recent social security reforms, such as, for example, the benefit cap, and demonstrates how they've disproportionately significantly impacted women. Chapter 11 concludes part 2 with a further reflection on the direct impact of the administrative state and frontline decision-making upon the lives of individuals, this time through the prism of Alex Powell's chapter, Administrative Violence, First Instance Decision-Making in Sexual Diversity Asylum Claims. And his approach takes a case study approach of asylum claims made by sexually diverse people. The chapter demonstrates the lack of guidance that exists for frontline decision makers to determine whether a claimant is in fact a sexually diverse person, and it shows the factors that exist to ensure that claimants have poor access to appeal routes. So through these chapters and throughout the collection, we see that the collection and the author's contributions challenge some of the received wisdom and assumptions that exist in constitutional law. And in doing so, we can see that the chapters touch upon several key themes. Notably, is particularly noticeable that there is, of course, this continuing impact of the British Empire and of colonialism's justification of racial hierarchies. Further, several chapters challenge us to think far more carefully about that very woolly line that exists between criminal law and public law. And another theme that I will mention now, finally, is this important reminder that I think most of the authors touch upon is this idea of the limits of the reach of public law, and the fact that there do exist limits to the remedial capacity of public law. And that is perhaps a bit of a dispiriting message, but it is, of course, a realistic and important one. And on that note, I'll be handing over now to Kanika, where we'll hear from her discussing her chapter on rule of law and racial difference in the British Empire. Thank you.
Thank you. Thank you for having me. I've got a few slides as well, if I could pull them up. Brilliant. Okay, so at SOAS, teaching started last week, and I teach on multiple modules, legal systems of Asia and Africa, and that's the module that I teach this this material on, law and society in South Asia. And what I begin with always is a discussion of law and colonialism. I think we've come to an understanding today that when we want to study law in the post-colony, we need to study about the roots of the law. And inevitably that leads us to the colonial encounters of law in the post-colony or in the colony at that time. And what I find striking always is that we don't do similar stuff for the subjects that we study as part of English law, right? So the subjects that we study in the LLB, somehow they seem to not have a history. And this is precisely what my chapter where my chapter intervenes and seeks to correct, which is that the principles, particularly the principles of public law, the relationship between the institutions, these were all formulated in and through colonial encounters. And therefore, it's important to bear those colonial encounters in mind when we examine principles of rule of law, parliamentary sovereignty, separation of powers. I will, of course, only be focusing on the rule of law. So in this paper, I look at the rule of law and racial difference and how that played out in the British Empire. I begin in the chapter, not today, but in the chapter by discussing the various modern conceptions of rule of law and how we understand it. And then we come to Dicey, right? And this is all public law textbooks start rule of law with Dicey, and that's where I sort of hang my hook as well. And this is the idea that, let me, okay, so Dicey, as we know, gives us that tripartite definition of rule of law. But he was writing at a time when the British Empire was rapidly expanding, and Dicey was part of those conversations about what law in the empire should look like. And one of Dicey's own belief was that he supported the rule of law, but he recognized that the rule of law, when imposed by one society on another, may itself be arbitrary and oppressive. However, the problem for Dicey did not lie with the doctrine of rule of law itself, but with the level of civilization that the colonized people may have achieved. So he believed that certain civilizations were simply too backward to appreciate the benefits of the doctrine. Despite these reservations, he had a largely positive view of rule of law. And he says here that the one permanent, certain, indisputable effect of English government in the East has been the establishment of the rule of law, right? However, if we look at Dicey's non-academic works, his political engagements, we find that in his political life, Dicey's commitment to rule of law was often overshadowed by his desire to preserve the Union. And this comes across particularly in the case of Dicey's response to Irish demands for independence and self-rule. So he's extremely critical of that. In fact, he even champions violence, armed rebellion by the Irish Unionists to keep the Union together, right? So this is just to say that when we study the scholarship of Dicey and others like him, we must bear in mind the political background against which they were formulating their theories. Now, Dicey here is not different from the others of the time. Other scholars in the UK other philosophers were also espousing similar theories. The idea that colonial rule was not about economic and racial exploitation of the colonized people, but about something else, was a persistent theme in the rhetoric of colonial rule itself. This something else was the civilizing mission, which included the supposed transfer of state and legal institutions, including ideas of rule of law, ideas of justice, liberty, good governance, etc., from the supposedly civilized Britain to the savage colonies. A part of this is, of course, this trade-off on trains. I mean, I grew up in India and I did not know about Indian trains while traveling on them than watching TV in the UK. There is constantly something on about trains. We get it. Trains was part of the colonial transfer. We get it. So what we also find is that a century before Dicey's interventions on ideas of rule of law, this debate on how rule of law should work in the empire was already ongoing. These debates, however, remain restricted to the UK and in the colonies, only the narrowest version of rule of law as formal legality was ever realized. So, for instance, most colonized people were denied the right to a jury trial, and far from being independent, judges were appointed at pleasure and were expected to be loyal to the colonial state. In fact, one of the examples that I give in the chapter is the Chief Justice of British Guyana being removed from office in 1868 because he was found to be critical of the state's treatment of indentured labor in British Guyana. So the Privy Council asked for his removal because he was said to have lacked judicial temper. And this is where I introduced the idea, Partha Chatterjee's idea of racial difference. Chatterjee talks about colonial difference, and that then gets extended to the idea of racial difference. Chatterjee has posited that the rule of colonial difference underlies all colonial legal systems. That is, that despite the supposed liberal ideology of the colonizer and their promises of equality, liberty, and the gift of law, the colonial system could only operate through a preservation of the superiority of the ruling group within the law. And so what we find is that often we are told that any divergence from the rule of law, any racial difference, colonial difference is incidental to the colonial legal system. And I think that what my chapter is trying to establish is that it is not incidental to the legal system. It is the very foundation of the colonial legal system. The colonial legal system exists by not having rule of law, by instituting, maintaining, legitimizing racial difference, where non-white population is treated as inferior to and therefore eligible for fewer rights than the white population. This becomes stark in Lord Sumner's judgment in the Privy Council in Re Sudden Rhodesia. Here, Lord Sumner says, and I quote, "The estimation of the rights of aboriginal tribes is always inherently difficult. Some tribes are so low in the scale of social organization that their usages and conceptions of rights and duties are not to be reconciled with the institutions or the legal ideas of civilized society. On the other hand, there are indigenous peoples whose legal conceptions, though differently developed, are hardly less precise than our own. When once they have been studied and understood, they are no less enforceable than rights arising under English law. Between the two, there is a wide tract of much ethnological interest." Race thus played an important role in determining the types of rights that were made available to the colonized populations. And as we know, during the 19th century, white settler colonies came to enjoy some of the freedoms that were supposed to be ideologically linked to rule of law, while the same freedoms were continued to be denied to non-European colonial populations. Nowhere were the limits of rule of law clearer than when the concept met the everyday racial inequalities that sustained the empire. At their most stark, these racial inequalities took the form of slavery that dehumanized the African origin population and remained legal till 1834. Not only did the colonial state turn a blind eye to everyday forms of racial violence in the colony, it also often directly legally endorsed racial discrimination against the non-white populations. One of the biggest controversies in India in this regard is the Ilbert Bill of 1883, which proposed to allow Indian magistrates to preside over cases involving European British defendants. After sustained protests by the white population, the bill was finally passed in 1884 after securing the compromise of ensuring that the white European population in India could only be tried by European British majority juries. Of course, a similar compromise was not made for Indian defendants. Direct racial discrimination was also apparent when the colonial state meted out punishment for crimes committed. And we find the most severe punishments were saved for violence committed by non-white populations on the white population. On the other hand, violence, everyday violence, committed by the white population was normalized and was an intrinsic part of the colonial capitalist structure that allowed white masters to have the right of correction, to brutally beat, flog, mutilate, or confine their workers as they saw fit. Practices, by the way, that continued long after the official end of slavery. So if we take as our starting point this idea that law did exist in the pre-colony, right? And even this is a departure from traditional understanding of law in Asia, Africa. I've got here two ideas, one of Marcel Granit on China, the other one, Henry Maine writing on India, both of which claim that there was no law in China and India before the Europeans reached there. And this is widespread. This is the idea that Asia did not have law, but Africa did not have a history, let alone law, is absolutely widespread in legal discourses of the time, in legal scholarship of the time as well. So if we take as our starting point that pre-colonial forms of law existed in Asia and Africa, we must accept that colonial law could only come into being by violently and illegally removing the pre-colonial order. Thus, in the colonial setting, the discourse on rule of law, with varying degrees of success, always seeks to hide this illegitimate origin of colonial law. This leads us to the inexorable fact that the rule of law and the rule of empire are inherently incompatible. And the latter, which is the rule of empire, can only be achieved by at worst annihilating the rule of law, or at best by upholding the weakest procedural notion of rule of law and using it as a fig leaf. That's me done. Thank you.
Thank you very much. So Ciara Fitzpatrick next.
Thanks so much, everybody. That's going to be a really hard act to follow, Kanika. Thank you for that interesting presentation. And thank you so much to Se-Shauna and Lizzie for giving me the opportunity to contribute to this really important book. I think as a social security lawyer, you feel like you're in a really niche area, working in a bubble sometimes. But in fact, you know, the case law really strikes at the center of public law norms in the English Constitution. And, you know, it was really, really important to be able to be provided with the opportunity to demonstrate that in some way. So my chapter is essentially split into two broad parts. The first part explores women's access to the social security system from a historical perspective, focusing on the post-war system's institutionalization of the male breadwinner model and the maintenance in so many respects of the same pattern of really patriarchy in the contemporary system. For example, through the maintenance of the single household payment and through the requirement that both members of a couple in the contemporary system have to sign a joint claimant commitment, which is essentially a contract with the state, which outlines their responsibilities attached to getting work and therefore being able to qualify to receive benefits. This principle is also known as welfare conditionality, which requires the individual benefit claimant or the couple to meet work-related obligations in order to receive benefits. It's extended to both partners in the couple with dependent children, and the couple is then required to nominate a lead carer. So in research quoted in the chapter, or cited in the chapter by Griffith et al., 27 out of 30 couples nominated the woman as the lead carer, which really aligns with the fact that women continue to shoulder the bulk of caring responsibilities in the private sphere. Yet some couples really did oppose this enforced designation of roles, as it effectively reinforced the classic male breadwinner model. Participants in Griffith's study were cynical of the imbalance in work conditionality, with no recognition of the other parent's role in child rearing in modern society. Lone parents found that their caring responsibilities were perceived as an active barrier to them entering employment. And though assurances are given by DWP that individual circumstances and caring responsibilities are taken into consideration, evidence which is cited in the chapter shows that they are really not properly accounted for in the context of the government's intense drive to ensure that individuals comply and secure full-time employment in the formal labour market. A recent example is really the whole concept of in-work conditionality, where social citizenship can no more be proved by working part-time, but a person has to gain full-time hours. So they have to find more work or better paid work while they are still claiming universal credit. Failure to comply with the obligations set out in the claimant commitment in the contract may result in a sanction, a temporary pause in benefit payment, which can have a devastating effect on the whole household. So not just on the person who has allegedly committed the misdemeanor, but on the other partner in a couple, or indeed in a lone parent's case, on the dependent children. Again, sanctions are increasing at an inordinate rate, and you may have noted in Jeremy Hunt's speech last week at the Conservative Party conference that he intends to further intensify the stick in the social security system by further really pushing sanctions on people as a form of punishment to get into the labour market. So the contemporary system is really characterised by extensive frontline decision-making powers, which fundamentally impinges upon an individual's ability to exercise a rights-based entitlement to social citizenship. Second noteworthy feature is really the skeleton nature of the primary legislation underpinning the administration of social security law. The contemporary system, the main piece of legislation is the Welfare Reform Act 2012, but most of the detail can be found in the 2013 Universal Credit Regulation, which has provided the Secretary of State with extensive powers to control the direction that the system has taken. I think Anderson, who I cite in the chapter, really sums up the unfair situation that women find themselves in. Where women were previously, and I quote, I should say, where women were previously excluded from social citizenship or were forced to derive such rights through their husband, now their access to social citizenship is predicated on entering the labour market on the same terms as men. This model of citizenship is situated as gender neutral, yet it exemplifies a male standard masquerading as universalism. And this neatly brings me on to the second part of my chapter, which focuses on the judgments handed down in the Supreme Court in respect of the benefit cap and the two-child limit. And for people who may not know what those policies dictate, the benefit cap means that any one household can only receive a certain amount from the social security system. This amount is set at a lower rate than what the average worker earns in the UK. So again, we're seeing that classic poor law principle of lesser eligibility really seared through the contemporary system. The two-child limit provides the child element of universal credit, or indeed child tax credit, which is being phased out as we speak, to the first two children born after the 6th of April 2017. So those who are impacted by the two-child limit are children who are under 7. We know that it has thrust over 750,000 more children in the UK into poverty. The gendered impact of both of these policies have been minimised in public discourse and by the courts due to the neutral status of social security law and the preeminence of the government's economic objectives in judicial decision-making. In terms of how teachers may be able to use this particular chapter, I think that the analysis of both the benefit cap and the two-child limit are strong examples of the current Supreme Court judiciary's refusal to comment on the government's prerogative to make economic policy, which has effectively led to a discrimination blind spot. I can still feel the visceral rage when I read Lord Reid's conclusion that more women than men are bringing up children. That is an objective fact. There is no suggestion that this is in itself the result of discrimination on the grounds of sex. Therefore, the differential impact on a woman is not a special feature of this measure. Reid is effectively accepting here that it's an objective fact that hardship is inevitable for lone parents affected by the two-child limit. He firmly situates the Supreme Court as unwilling to prevent indirect gender discrimination to accommodate a steadfast commitment to the doctrine of parliamentary sovereignty based on the importance of the economic objectives pursued. So I suppose my ending clarion call is that there is so much work to be done in inspiring a new generation of feminists to push for a renewed recognition of the disproportionate impact of caring responsibilities on women as a social barrier and not as an acceptable and an inherent feature of society. Thank you so much.
Thank you very much, Ciara, and thank you to both you and Kanika for giving us a really great flavour of the things that the book covers. And I think there are some commonalities between both of your chapters in terms of the gap between the promise and the reality of the rule of law. So we're now going to hear from the first of our two respondents. So I'm going to hand over to Vidya Kumar.
Hello everyone. I am just so pleased that I've unmuted myself. I think I should be congratulated for that. It's been a while since I've been using Zoom. So first of all, thank you so much, Professor McHarg, for inviting me to speak today at this ICON event. And at this, discussing this new edited collection, which is so exciting, which has been curated by Professors Wheatle and O'Loughlin. Sorry, apologies for my mispronunciation there. As I only have 10 minutes to speak, I can't comment on all the wonderful contributions that this text has to offer, so I can only offer a few reflections. However, I wanted to start off by commending the editors, not just for embarking on the onerous task of collating and adding a diverse set of public law voices to the field, but for daring to confront the omissions and the shortcomings and the flaws of traditional preoccupations and understandings of public law. I've been teaching and lecturing in public law for over 11 years now in the UK, and I became increasingly frustrated with the myopia and the narrow gaze of UK public lawyers in terms of, and also in terms of the cases and in terms of the scholarship. Many important issues, questions, and topics which were not being addressed in mainstream public law courses, textbooks, monographs, and conferences really frustrated me. So the important issues I am concerned with here, which many public law students and UK citizens more broadly are concerned with, include the numerous oppressions and inequalities in the UK that affect public law and shape public law, namely systemic racism, ableism, sexism, classism, poverty, homophobia, transphobia, xenophobia, ageism, and religious intolerance. And that list is not exhaustive. These inequalities are what shape our social, economic, and political and legal landscape. And I got so fed up that last January, I ended up co-founding an organization called Race in the UK Constitution Association in order to remedy in an intersectional way the omission of race, racialization, and racism in British constitutional law, teaching, and history, including Britain's colonial history. And what is so wonderful about this edited collection is that finally you have a collection of public law chapters which have more than one chapter, so it's not as a token, but more than one chapter addressing the question and importance of race, racialization, and systemic racism in the UK, in UK public law. And my comments will be addressed mainly to these chapters. Now, in saying that, I want to underscore that every single chapter in this collection is an absolute gem and fills a blind spot in the field, truly. And I really congratulate all of the authors in this collection and the editors for bringing it together. So when people ask, where is the discussion of race and colonialism in public law, we can now say that my brilliant colleague at SOAS, Kanika, who's just spoken, takes this on in her chapter 1 in the rule of law and racial difference in the British Empire. And she does an absolutely superb job of delineating the role, origin, and application of the rule of law in maintaining the British Empire and colonial subjugation. And not only does she engage with traditional understandings of the rule of law, as posited by Dicey, Raz, and Bingham, she traces in detail how British law and its principle of the rule of law in particular operated as a coercive instrument in the dispossession and subjugation of colonized people, often hiding and justifying the violence of British colonial rule in order to facilitate resource extraction from the periphery to the center. And her chapter is not just a must read, it's a must assign. It is what every UK public lawyer or even jurisprud who teaches the rule of law in any serious way must assign as an antidote to the benign and tired conceptions of the rule of law, which are all too often spoon-fed to our students. It's important to have such diverse views, like Kanika's view of constitutional principles, offered to students, and to have such views taken seriously, taught, and not ignored by mainstream public law scholars, especially as we know that the rule of law, and I say this with some irony, is sometimes viewed as the jewel of the crown of the principles of constitutional law. Several other chapters in this collection are equally groundbreaking in bringing race, racialization, and racism into the mainstream public law discussion. Too often, terrorism and counterterrorism are topics which, if discussed in public law, are not discussed in ways which expose the disproportionate effect these laws have on people of color, and in particular, upon brown Muslim men. Mainstream textbook discussions of the impact of counterterrorism law are discussed as questions involving the relationship between the individual and the state, the protection of civil liberties versus national security, the question of balancing human rights against government policy. And you see Chowdhury's chapter on counterterrorism in law and policy is such a wonderful and needed corrective to the colorblind approaches of extant public law scholarship, which ignore the material effects of systemic racism on the creation, design, and operation of public law. He traces how the processes of racialization are in fact embedded within the exercise and implementation of counterterrorism law and policy in the UK. And he offers a really succinct understanding of race and racialization. For those of you who find those words too difficult to grasp or even just to teach, look at his chapter. And I have to say the remarkable clarity of his writing reminded me of Oxford's Shreya Atri's wonderful lucid piece on structural racism and race discrimination in the journal Current Legal Problems in 2021. But specifically, Chowdhury capably documents how counterterrorism and the policies and its policies intensify and extend the processes of racialization of Muslims, often through the exercise of discretion that draws on Orientalist and colonial tropes, framing all Muslim men as violent and aggressive. At the same time, he shows these laws and policies, unlike other criminal laws and other policies, require Muslim men to constantly show through their appearance, behavior, and opinions that they are not the quote unquote wrong kind of Muslim. Further, he identifies the many obstacles for young Muslim men and their families to have mounting challenges to this racial discrimination, which is inherent in counterterror programs like PREVENT. And this fact, these obstacles, so some of the obstacles include the socioeconomically marginalized position of British Muslims and the fear and anxiety and stigma that accompanies terrorism-related investigations. Those obstacles to mounting challenges to this racial discrimination, that fact means that these forms of systemic racism against British Muslims are likely to be perpetuated in the future and reproduced indefinitely. Again, this chapter is a must read and must teach, one for those public lawyers who wish to move away from the idea that race and racism is somehow something outside of their discipline. It's something over there. It doesn't shape it. It doesn't affect it. And to recognize and approach public law as a subject which participates in and reproduces broader relations of domination. And what is really wonderful about Chowdhury's chapter is that its comments on racialized subjects and citizens are actually played out in another chapter by Professor Prabhat, the chapter on the Begum case and parliamentary sovereignty. Those two chapters really speak together to each other. Her wonderful chapter illustrates many of the points that Chowdhury makes, although her focus is primarily on the ways in which citizenship stripping is dealt with by the judiciary and how judicial decisions often show deference to the executive branch in ways which fail racial and ethnic minorities, and which puts those racial and ethnic minorities at risk in countries where democratic majoritarianism contains elements which lean toward authoritarianism. Finally, Ben Bowring and Shruti Iyer's wonderful chapter on racism and anti-discrimination in policing examines how the police, a key yet sometimes neglected actor in public law, have been governed under anti-discrimination law. And it shows how public law is shaped not by black letter law, but by, and I like this phrase, blue letter law, namely the everyday discriminatory attitudes and beliefs which imbue policing practices. And this is corroborated by the Casey report, the recent Casey report. They argue that any analysis of public law, particularly anti-discrimination law, must be embedded within a wider analysis of the social, historical, and political processes within which all law operates. And when this context is taken into consideration, this wider context, one is able to see not only how government policy underpins and exacerbates new forms of racism, but how anti-discrimination law itself has failed the victims of racism in the UK. And as a final comment I want to make, because I'm pretty sure Aileen is going to tell me my 10 minutes is up. I just want to say to note the absolute brilliance of the editor's introduction. There are so many introductory arguments and observations about public law and the study of public law that the editors make, which deserve amplification. Reading it was like finally reading the public law textbook that I longed for 11 years ago. This is the textbook I wanted to read, this introduction. So I have to thank them for this. And I have examples about the introduction that makes it unique and different from all other public law textbooks that I have. And I have about 10 of them. And I've read all their introductions, and this is just exceptional. And I'm happy to go into those points that I think are important to highlight, but I'm going to leave it there.
Thanks very much. And finally, Surya Roy.
Thanks very much, Aileen. Thank you very much for having me on this panel. It's unlike Vidya, when I first came across the book, I resisted it, I have to be honest. And I resisted it for two reasons. One is, whenever I come across a good edited collection which doesn't have me as a contributor, I'm really upset. This is number one. And the second is, if there is a book which talks about diversity or makes a claim about diversity, I sort of wonder whether it's an exclusionary claim when it comes to a notion of diversity. So let me first try and say why I initially resisted it, and then why I saw the light, and then subsequently, to discuss a couple of themes which I think is common in the book, and then finally some suggestions on how we can take this project forward. Notice how I slipped the we into this equation. But on the idea of why I resisted it initially, some of the chapters in part one of the book, with the exception of Kanika's chapter, which I thought was brilliant, and I'll get to that in a minute, I felt that in content, tone, and citation practice, they read like mainstream legal articles. If you pick up a mainstream legal journal, if you pick up the tone and the way in which legal scholars, especially in the UK and Ireland, work, it seemed to be following a similar idiomatic practice, like the language and the tone and the citation practices were a little bit similar. But however, when I then read these chapters in relation to part two, it made sense to me. And let me try and explain how that happened. And I can explain this with the help of two anecdotes. The first one is before I sought out the gentrified world of Western academia, I was sort of working with a couple of NGOs in Tibet and in other parts of the world. And one of the practices that you find, especially with the Department of Information of the Tibetan government in exile, is they are in the habit of producing shadow reports. So when the Chinese government launches an official report, then the Department of Information launches a shadow report on exactly the same subject matter. So I now see this book as a sort of shadow public law book, that you have all the mainstream public law books which assume neutrality and which assume a sort of acontextual approach to thinking about public law. This book is the shadow book, that this is going to be read as an alternative to the mainstream public law books which are available, which might look at the context of public law. Another example is, I personally love public law, and I try to stay away from contract and tort law as much as possible. But the best book I read last year happened to be a contract law book. This was a Canadian legal scholar. His name is David Sandomierski. He wrote a book called The Aspiration and Reality in Legal Education. And the argument he makes is that students should be given the choice while they're studying contract law to go down the black letter law approach or go down the constructivist approach. So what he does in the book is he first gives a doctrinal summary of contract law. Then he does a shadow summary of contract law looking at construction, relying primarily on critical race theory. And then he says there should be 2 textbooks and the module should be designed where students can go down either of these routes. And I think, once I sort of understood a little bit as to why this book is so valuable, that even the chapters in part 1, which talk about delegated legislation and parliamentary sovereignty, even if they speak in a manner similar to mainstream legal scholarship, they are slightly and subtly changing the meaning of the orthodoxy in their own ways. So even if they may not talk about issues which we think are diversity related, which could be issues of empire or which could be issues of race or gender, but by changing the way we understand democracy, changing the way we understand rule of law, they become excellent ways in which to appreciate the contents of part 2. So this is sort of the way I got to terms with the different ways or diverse ways in talking about diversity, if you will. So this is the way, I initially resisted the book and then I came around to thinking it's excellent. And in the second part, I do want to see if there are common themes that emerge from the book. Now, it seems the editors, and correct me if I'm wrong in thinking this, have resisted a prescriptive attitude to the contributors in saying this should be the definition of diversity, or this should be the approach or analytical method which should be followed in your contributions. And I do think that's truly a remarkable choice, an editorial choice, in not being extremely prescriptive about the content and themes that are followed. Having said that, I do think from reading the chapters, there are a couple of big ticket, big picture items that emerge. And again, the way I get around to this is by reading something unrelated. And the unrelated literature which I'm referring to is a couple of books by Aziz Rana on American constitutionalism. And what Rana argues is that the American Revolution should be viewed as a sort of settler revolt. And the whole history of American constitutionalism can be viewed as a sort of settler constitutionalism that tried to define its own against the empire, as well as against minorities, as well as against oppressed classes within the settlement. So it is in this way American exceptionalism tried to justify itself. And what I think is especially interesting reading Kanika's contribution is he argues that the justification for settler constitutionalism required the rule of law, and it required the American values of liberty, which became the centerpiece of the American Constitution. So in a strange way, the neutral values of public law were conjoined with the material interests of American settler colonialism. Applying that sort of way of thinking to UK public law or the empire, we don't have a sense of settler colonialism, but we do have a sense of extractive colonialism, which then shaped even the domestic life of British law. And you get this from Kanika's conclusion. I do wish, Kanika, you do expand on that conclusion where you're hinting at how the duality of the rule of law in the empire came back to bite itself in the back, whereas domestic rule of law was fashioned by the problematics of empire rule of law. I do hope in your next chapter that is your central investigation. But I do think there is merit to the point that when we talk about domestic public law in the United Kingdom, that you cannot escape the meanings which have been attributed to these values of rule of law and freedom and liberty and non-discrimination from its experience in the colonies. One example, for instance, has been given by Niraja Gopal Jayal in a book on citizenship, where she argues that fingerprint analysis and the birth of face recognition technologies was in British India as a way to control colonial dissent, which was then imported into the United Kingdom as a way of regulatory governance. So you do see a sense of the let's say control of the colonies using the model of extractive colonialism, which then becomes part of domestic law when it comes to the UK. So I do think, much like Aziz Rana's idea of settler colonialism, what defines, I think, UK public law to a great extent is extractive colonialism and the empire. And it is this theme that runs through several of the chapters. So for instance, when you have chapters on the Begum case, or when you have chapters on the counterterrorism policy, you do have a sense of how discretion related to migration is something that shapes administrative law in general. And this is therefore, again, an example of extractive colonialism, whereby you allow the transfer of resources, but not the transfer of people. And it is to police this border that administrative law is constructed. So I do think this general theme of extractive colonialism and the practice of citizenship and migration that follows is something that shapes the mainstream administrative and constitutional law of the United States. So that's the general theme which I sort of identify. The third point which I want to make is where to now, which is I've got around to the fact that this is indeed an excellent book, and I'll be prescribing several of the chapters in my first year legislation and regulation class. But then the question is, what do we do now? And here I think for the editor's next project, or as a community, I do believe that we should take this idea of diversity in public law further. And here I think we can make some radical suggestions for changes. Number one is that when, let's say, Patricia Williams published her book on the alchemy of race and rights in the United States, it took legal academia by storm. To a great extent, this is because there was a tone and a manner of speaking whereby personal experiences or the sense of injustice is transparently articulated before legal analysis is executed. And I do think this method and tone of doing legal scholarship, which is influenced by affect theory now, should become mainstream legal scholarship. So the dominant journals in public law should be receptive to this way of doing legal scholarship, where we are completely transparent about the reasons why we are writing these articles in the first place. So I do think the way legal scholarship is done should be shaped by this start which the editors have put in place. The second is there is a sense of maybe when we are talking about diversity, we collapse into a particular standpoint, whether it's gender or race or some other standpoint. And I do think this is it's not false, but a simplistic argument, and which is countered by the idea that when it comes to injustice or oppression, or any issue of injustice or oppression, there should be an epistemic solidarity between communities and practices that try to contest the neutral privileging of legal doctrine. And this is something you get, for instance, in Derek Jacobi's book on a realistic Blacktopia, where he argues that it is big tent epistemic approaches rather than small tent community-related approaches that are actually going to be more effective in re-territorializing the generality of law. Finally, the last point which I do want to mention is, and I know this is a controversial point, but to a great extent, the neutrality of legal doctrine has been linked to institutions of power in legal academia. whether it is being in the same network as judges or regulators or financial institutions, I do think that it is about time that we confidently assert independence from these institutions in articulating the doctrines which we think are central to public law. And to my mind, this would radically allow for a reterritorialization of public law to accommodate the diverse strain which the editors have introduced. Thank you very much.
Thank you very much, and thanks to all our panelists again. We don't have a huge amount of time, and there's no questions in the Q&A box at the moment. So what I'm going to do just in the last, I think 6 minutes that we've got is just to invite the editors and the two authors to respond briefly to the comments of our two respondents. And in particular, can I ask you to address that question of how we actually operationalize this more sort of diverse approach in our teaching practice? Because I can imagine that the standard response would be, well, this is all very well, this is all very interesting, but we've got limited time and we've got to get through a series of standard topics. So what's the approach that should be taken? Who wants to start? Shauna?
Sure. So how do we operationalize this? I think perhaps we challenge some assumptions. So I think that's something that a lot of the chapters do in both in both part 1 and part 2. So challenging assumptions about the rule of law existing as a force for good, this idea that the UK Constitution generally opposes the rule of law. And I think there can be a tie made to the kind of colonial approach to rule of law and rule of empire to some of the topics that we teach now in the rule of law. So for instance, in discussing the bank code case and thinking about the ways in which there's still a colonial legacy that limits the reach of the main requirements of the rule of law, and that there's a differential experience for citizens in the UK and individuals who still occupy territories owned by the UK. So I think there's a route there for tying some of these ideas and some of these challenges of assumptions to some of the topics that we teach and how we teach some of this case law, kind of encouraging students to critique their own country, which I know we all find to be a bit difficult when we teach first year UK Con. And I think something else that came up in looking again at the chapters after a separation of some months since publication, and in hearing the respondents speak, something that comes up again is this idea of discretion and what role does discretion play? How is it used? How does it manifest, but also increase the inequalities and discrimination in society? And I think there's something there for us to critique the role of discretion and to say more about how it interacts with the everyday lived lives of people, because that is their main interaction with the state. It's through engagement with frontline decision makers. So I think we need to kind of problematize discretion to some extent and encourage students to do that. I'll stop so that someone else can speak.
Thank you. Ciara or Kanika, would you like to come in? No? Anybody else want to? Oh, Ciara, great.
I was just going to say, I think that there's definitely something in the idea of providing students with choice. So yeah, so it probably will take a bit of, and this is hard too, because where does everybody get the time? But I mean, a bit of redesign in terms of the traditional curriculum to give students the opportunity to look at the other side of the coin, the more critical perspective. So it is, teaching the traditional kind of subjects, potentially one half of the lecture, and then flipping it over and looking at different and diverse kind of opinions that are set out in this book, or using it as a really good tool for discussion, like for small group discussion and seminars, and in other sort of forums, even other modules. Like I also teach an optional module in social justice, and there's no doubt that I'll be able to utilize the chapters in this book in that module as well. So it probably takes a wee bit of creative thinking, and you know, probably the big question is, how do we sort of encourage our colleagues to use this textbook in that way, and to really kind of encourage them to look at different arguments that can be made.
Thanks. A final very brief word to Kanika or Lizzie? Kanika.
Thank you very much for the commentators for actually summarizing my chapter better than I did. So thank you very much. I think the one point is, do we want our chapters to be read alongside more traditional chapters in public law? Definitely yes. Does the curriculum have the space for that? I think the space needs to be created. I don't know how many people are willing to do that, and as Ciara mentioned, where's the time to do that? But that doesn't mean that some of the critiques that we raised cannot be now introduced into the more traditional textbooks. So the thoughts can be put in the textbooks, even if there's no space for the entire chapter to be read by the students. So I think if there is a will, there is definitely a way to engage with the materials in the textbooks and the comments that we are making, and make it more mainstream and not just the diverse out there.
Great, thanks. And I'm seeing a comment in the chat from Lizzie. Final comment would be not to underestimate student appetite for more critical and historical perspectives. And I think that's probably right as well. So thanks again to everyone. I think we do need to wind up, I'm afraid. I think we could keep going for much longer if we had the time, but alas, no. So thanks again to all of our speakers, and also to Matilda Brun, who helped us to set up the webinar, and of course to everyone who attended. And just a final reminder, if you are inspired to buy a copy of the book, Bristol University Press are offering a 50% discount on purchases from their own website until the 1st of November. The discount code is CNF23. I did put that in the chat earlier. So thanks again, everyone, and hope to see you again in some other event in the near future. Thank you.
Thanks so much, everyone.